So I'd like to talk now about the Right to Repair Act in Georgia. So the Right to Repair Act was created by the Georgia legislature as a means for contractors and homeowners to resolve disputes. It was designed to encourage them to do so. So it provides a framework for resolving disputes. I'll share my screen here and show you. All right. So this is the language that your construction contract would need in order for you as a contractor to invoke the Right to Repair Act as a means to resolve your disputes. So we'll talk about what the Right to Repair Act does, but at the outset, this is the language that you'll need to include in your contract in order for that statute to apply, for the framework to apply. So it puts the owner on notice that the contractor has an opportunity to follow the procedures in the Georgia Right to Repair. Well, what does the Right to Repair Act do? So it contains very specific deadlines and requirements for owners and contractors. So in order to invoke the Right to Repair Act, an owner must provide notice to the contractor of the defect. So what they would do is they should send a certified letter to you as a contractor describing the problem, submitting any evidence to support it, and you would have an opportunity to then review that. So you have 30 days as a contractor to respond to that. You have the right to inspect the property if you need, in order to make a decision. As regards to the repair, you have the right to inspect. You can make an offer to the owner after getting this notice, or you can reject the claim. You can just say there is no defect and we're moving on. But if you do inspect, then the statute gives you another 14 days to respond after that. So we're at 44 days now if you want to max out the timeline. But after that opportunity to inspect, if you choose to do so, you can do one of four things. You can propose a plan to repair. You can offer to pay money to settle. You can do some combination of both. You can offer to repair and also offer compensation, or you can just reject altogether that any repairs need to be done. So then this all needs to be done in writing, so you provide that to the owner. And then the owner can choose whether they want to accept your proposal or if they want to reject it. If they reject it, then the statute gives you another opportunity to propose another offer to resolve it. So again, you go back up to the list of four things you can do, but you have another 15 days in order to supplement the offer. So here are some things to note about the Right to Repair Act. It is an informal process, meaning that there's no other people involved in the process, just you and the owner trying to work things out. And that's the most cost-effective way for you as a contractor to do it, and it's the easiest way. That's one of the reasons the law was passed is let's encourage parties to resolve these things themselves. It's designed to encourage settlement. It provides a framework for doing so. So when we looked at the prior slide, you'll see that the first step is the notice by the owner. So sometimes the owner won't provide the notice. So what happens in that case? Well, you as the contractor can invoke the Right to Repair Act. So if the owner doesn't provide that notice to you, and let's say they file suit against you, then you can stop the lawsuit by invoking the Right to Repair Act. And what that does is it forces the owner to go through this process to provide you written notice of the claim, provide the evidence, gives you a chance to inspect, propose a reasonable repair, and all this occurs, while the lawsuit is stopped. so that y'all have an opportunity to do this. The other thing it does is it limits an owner's recovery. So if the owner rejects your proposed settlement, so let's say you propose a repair, to say foundation repair or something, the owner rejects that proposal and then wants to proceed with the lawsuit anyway. Well, if the fact finder, the judge or the jury finds that your proposal was reasonable, then the owner is limited in its recovery to the value of that proposed repair. So if you proposed a $2,000 repair, but the owner was like, I need a $50,000 repair, then the owner, if they ultimately win, they only get the value of that proposal that you made, assuming that the fact finder finds it a reasonable proposal given the circumstances. It also precludes the owner from recovering any attorney's fees. So it's really has a lot of teeth to it, in that so long as you take the repair request seriously and you propose a serious response, then the owner should seriously consider that. And if they don't, there are repercussions in their doing so. So that's just kind of a brief overview of the Right to Repair Act in Georgia. Obviously, there's a lot more to it. Have been a lot of cases interpreting it, but those are the basics. And again, it's a way to try to encourage the parties to settle and resolve these disputes. For more information, feel free to contact us at downslawllc.com.